Tom Abbate with Parnham and Associates here again today to talk to you about state jail felony possession of controlled substance cases. These cases are going to be possession of a controlled substance. Typically, it will be either methamphetamines, cocaine, or heroin, but it's going to be an amount that is less than 1 gram. So we're talking about trace cases, anything from some residue in a bag all the way up to 0.99 grams. Now, these are state jail felony offenses, and what that means is that they are not quite a third-degree felony, but they are greater than a misdemeanor. The punishment range for a state jail felony offense is 6 months to 2 years in a state jail facility and a fine not to exceed $10,000. The thing that you need to keep in mind with state jail felony offenses is that you're not going into the normal prison system if you are placed in a state jail facility, and there are some differences in how it's handled. The biggest difference is that there is no true parole. If you are sentenced to 180 days, which is the minimum, you can expect to do 180 days regardless of good behavior, work time, or any of those factors. There is a provision where the state jail and TDC that runs it can give you a credit for 20%, which is similar to parole. Essentially, 20% of your sentence you would not actually serve, but they would count you as having served it. That is completely at the discretion of TDC. You do not get a hearing. There is no administrative review. It's that if you do some of their programs, they may credit it to you, but they can jerk it away without any real review of that decision. Now, the thing to remember about state jail felony offenses is that they are felony convictions. So if you end up getting convicted of a state jail felony, you can expect to lose all of the same rights just like you would with a third degree or a second degree or even first degree felony. You won't be allowed to vote. You won't be allowed to own a gun for the first 5 years at all. After 5 years, you can own one in your home, but you cannot take it outside. You've also got the federal restrictions that would ban you from owning any kind of handgun permanently or anything like that. So it's very important that even though it is a small amount of drugs, that you handle the case appropriately. Now, if you have no other criminal history and this is your first offense, by statute, you are entitled to some form of probation. This can be deferred adjudication, which would be the most likely type of probation you would be offered, but it can also be straight probation. As with any deferred, you've got to keep in mind that while you're sentenced to a term of years for your probation, if there's any violation of that probation and you are adjudicated, the entire 6 month to 2 year period is available to the trial court. Whereas with straight probation, you're told that you would be going in for, say, 1 year, but that sentence would be probated for 2 years on community supervision. If you violate your community supervision, you are going to the state jail facility for a 1 year term. And so there's differences between the two. The deferred, if you successfully complete it, you're not going to be taking a felony conviction and you will be entitled to have your records sealed. Whereas with the straight probation, you're taking that felony conviction. So you've got to kind of weigh those risks as to which one is the better deal. A lot of people look at the deferred because they say, hey, I can just do this probation and I don't have a felony conviction. But, if you violate any of the terms, you could end up actually making your situation worse. There are also a couple of other ways to resolve a case if you're not, seeking a not guilty at trial, which would be under 1244. We've got two subsections to 1244, A and B. 1244A, which is the most common, allows the trial court to convict you of a state jail felony, but sentence you to misdemeanor time. This would effectively result in you being confined in the county jail for a term not to exceed the term of a Class A misdemeanor, which is up to 1 year in the county jail. Things to keep in mind about county jail time is that depending on your county, the sheriff's department who oversees that jail may calculate your time differently. Here in Harris County, our jail is typically pretty full. We have a lot of people coming in and out, and so the sheriff's department here typically gives you at least 2 for 1, meaning that each day is going to count as 2. So if you're sentenced to 6 months, you can expect that in all likelihood you are going to actually only do about 3 months. There's also ways to get your time credited more favorably to you by, say, working in the jail as either as a trustee, maybe working in the kitchen, maybe doing cleaning, laundry room, stuff like that. Typically they'll give you more credit for your days if you're doing a job for them, and if you're sentenced to a longer period of time, they are more likely to put you in one of those positions. So for instance, if you're sentenced to 180 days in the county jail under 1244A, you may be actually only doing about a month or 2 because they're giving you either 3 or 4 days credit for each day that you serve. And so that can be kind of attractive. However, keep in mind you are taking a felony conviction on that, and all of the consequences of a felony conviction will be applied to you. No voting, no right to own a gun. The other option is 1244B. This is a much harder option to get because it does require the consent of the district attorney's office. 1244A, the judge can sentence you to independently of what the district attorney wants to do, but under 1244B, they have to have the consent of the district attorney, and there's nothing you can do about that. That's laid out in the statute. Under this subsection, you actually take a misdemeanor conviction and you do misdemeanor time. That could be misdemeanor probation, it could be time in the county jail, but the thing to take away from that is that you will be taking a misdemeanor conviction. So you'll be able to own a gun, you'll be able to continue to vote, you'll have all your normal rights, it will appear on your criminal history, and you won't, unless you take some kind of deferred on 1244B, which most of the time the district attorney's office is not going to be in a big hurry to offer you that, but it is something that you can fight for. You're going to be looking at, completing that, maybe getting your record sealed, and it's going to effectively be like it never happened. Law enforcement, licensing authorities can still see your criminal history once those records are sealed, but the general public, your normal job search, criminal history search is not going to see that information. And so those are different ways that you can resolve a state jail felony case. The best way to resolve it is always going to be trying to minimize what the consequences are. And one way that you can ensure that your attorney can do that for you is to keep in mind what your rights are. These are always typically going to be possession cases. And so, search and seizure is going to be the issue. Keep in mind that you do not have to consent to anything that the officer is asking you for. If they want to search your car, you can tell them no. They can go get a warrant. You also want to watch what you say. You have a Fifth Amendment right to silence. Use it. You don't have to answer those questions, and you can terminate that interview at any time. And then the police can still search your car and seize evidence, but it's much more difficult for them to do that when you are not an active participant. And so remember your rights, stand on them, and that should put you in the best position possible to resolve your case if you are found to have a controlled substance in an amount less than 1 gram.